Hi, Lee Phillips here. I want to talk to you for a minute about putting property into a trust. Living revocable trusts, everybody I think should actually probably have one if you've got property. However, they fail in most families because the lawyer doesn't teach them how to fund the trust. The trust has to own stuff, the stocks, the bonds, the bank accounts, the brokerage accounts, the real property. How do you get the real property into the trust? Well, you're going to have to deed it. That's the only way that you transfer property, real property, is through a deed. So we're going to make out a deed from you. I assume it's in your name now. If it's in your LLC or something, you're not going to put it into the trust, just the stuff that's in your name. So you're going to make out a deed going from you as the grantor to the trust. And the trust is then going to be the owner. A couple of 3 or 4 things we've got to talk about. First of all, what kind of a deed do you use? You can use a quitclaim deed in this situation. If you're moving property to an LLC from you to an LLC or something, then you should be using a warranty deed because you want the warranties that are associated with the prior deed and the property to go along with the transfer. In this case, though, basically all we're doing is we're taking the piece of property from one of your pockets and putting it into the other pocket. You technically still own it. Well, technically you don't own it. Legally you don't. The trust does. But for all practical reasons, you own it. The courts say you still own it. The IRS says you still own it. Everybody says you still own it, kind of. So a quitclaim deed, moving it from one of your pockets to the other pocket, will work. The warranties are still with you because we didn't change you. So most attorneys use a quitclaim deed when they transfer property from you to the living revocable trust. By the way, a quitclaim deed means you quit claiming any interest that you have in the property and you give that interest, whatever it is, to the person that the deed goes to, the grantee. So we're going to use a quitclaim deed probably. It goes from you to the trust. On the trust, you have to have 3 parts to the name of the trust. And I've told you this lots of times. You have to have the name of the trust, and that could be your name, the John Doe Living Revocable Trust, which would be abbreviated John Doe Trust. But in this case, use the whole name. The John Doe Living Revocable Trust, under agreement or dated such and such a date, and then the name of the trustee, John Doe Trustee. So you're going to be the guy who gives it up, and you're going to be the guy who takes it as the trustee. Technically, the title is held in the name of the trustee. And I get 1 or 2 cases a year where the attorney or the title company or whoever forgot the date on the trust, or they forgot the trustee's name. So you got to have all 3 of those elements: name, date, trustee. And you've got to have the property description. And you've got to have your name as the grantor. Your name has to be exact on that quitclaim deed, exactly the way it is on the deed as it is now, as you own it now. If it's John L. Doe, then it needs to be John L. Doe on the quitclaim deed. If it's John Doe on the original deed and you put John L. Doe, that ain't going to work. That isn't exactly the same. The names have got to be the same. The property description's got to be the same. And the name of the trust, once you've got those, you're pretty much just in a standard deed situation with a quitclaim deed. Now, is there a tax consequence? The answer is no. However, some states have passed laws. For example, California has Proposition 13 that says we can't increase the property taxes on your property until it changes hands. Then we get to increase the property taxes. They did this back in the 70s or whenever because the property values were going up so fast in California, and they were increasing the property tax every year, and the people were going, I can't do this. So they said, okay, time out. We will only change the property tax when you transfer the property. Well, this is a transfer of property. Okay. Prop 13 says, well, it's from you to you. The law says it's from you to you. So in California, for example, you simply have to tell the state, file a paper with them, that says we've just transferred it from me to Living Revocable Trust. And then they won't increase the property tax. If you're in Florida or Texas, you've got to worry about the homestead. You should have a paragraph in your trust that talks about the homesteads. And you may have to go down and file a paper with the state saying, no, time out. This is still my personal residence. I get to homestead it, even though it's in the name of the Living Revocable Trust. Call up your county recorder, your parish recorder if you're in Texas, and they should be able to tell you what the scoop is on that. So those are things you have to worry about. You shouldn't have to worry about your insurance. It'll still be in your name. That's fine. It's you. It's not like you transferred it to an LLC or something where they get to change the name of the game. You may want to have the insurance company recognize that it's in a trust, but that's usually not necessary. You shouldn't have to have an increase in the property taxes. In fact, the law says they can't increase the property tax on me. Now, you may have to notice them like you do in California. And I think California is the only one you have to do that with. I'm not sure, but check. And so what else do you need to do in order to transfer real property into your Living Revocable Trust? That's about it. It's not hard. I would record the deed. If the deed ever gets lost, then the recording of the deed works. I don't even need the deed once it's recorded. So record the deed. That's probably a good idea. So if you don't worry about losing the deed, you could keep the deed and not record it, and then the family could record it after. But you might as well record it. Then we know it's there, and everything's cool. So if you don't record it, what do you do with it? Well, what do you do with it anyway? You put it in your file cabinet or wherever, put it in your safe deposit box. I don't care what you do with your deed. Wherever your deeds are normally kept, keep this deed with those deeds. You should be able to transfer your piece of property with really not much problem, as long as it's from you to the Living Revocable Trust. Use a quick claim deed. Make sure the name of the trust is there. Make sure your name is there exact as it was before. If it's you and your wife, husband, you got to have everybody's got to sign. And of course, the deed has its 7 or 8 elements that you have to follow, but we're not going into that right now. So this is Lee Phillips talking about how you move a piece of real property into your Living Revocable Trust.